Prior to today's pre-hearing conference, the three parties had to meet and agree on the issues to consider. However, the petitioners' lawyers did not attend the meeting, neither had they finished preparing the affidavits they are expected to present.
We suffered a setback when some of our witnesses continued to go missing as we attempted to access them, having sent somebody to pick them from Barara where they were dumped without transport, and they were using strangers' telephones. We were informed that some of them were engaged in a meeting with the Deputy Inspector General of Police, who had picked interest in the same.
The court pushed the session to 24th of February as part of the roadmap issued by the Chief Justice. According to the program, the petitioner has up to Sunday 14th to file all affidavits and serve the respondents. Then until 20th of this month, the respondents will file their responses to those affidavits. On 23rd February, parties will file any rejoinders and proceed with pre-hearing on the 24th and also any applications to be made. Between 25th and 26th of February, court will allow parties to cross-examine witnesses, present any electronic evidence and oral submissions. The parties will then proceed with written submissions, and the petitioner has up to 27th of February to file the submissions. Respondents will have up to 2nd March to respond to the submissions. Between 3rd and 4th March, the petitioner will submit any rejoinders. From 5th March, court will again allow oral submissions with strict time limits. And between the 7th and the 17th of March, the justices will retreat to prepare their summary judgment to be delivered the next day.
Summary judgment to be delivered on the 18th of March, so that we are within the 45-day period. As you can understand, if you disturb this schedule, we'll run into problems.
The Chief Justice ordered all parties to set up desks at court to ease filing and serving, and the court registry will remain open even on weekends.
In the court, mainly we'll be receiving those affidavits. That is the main thing, plus the submissions. That will be the main activity that is going to take place until that day when they have filed all the affidavits and they would want to come and cross-examine the witnesses who have shown the affidavits. That will be a day in the court where the other parties and the lawyers can be physically in the courtroom.
Alfonse Owiny-Dollo also asked for maximum cooperation from all parties. This after Kyagulanyi's lawyers informed the court of an intention to recover evidence from the Electoral Commission.
There is absolutely no reason why the petitioner must apply to court for discoveries. If there are any documents in the possession of your clients which the petitioner wants to use, they should be availed easily.
The lead jurist also came out strongly on the rule of sub judice. As the former NUP presidential candidate races against time to prepare and file all evidence amidst alleged disappearance of his witnesses, his lawyers say they may turn to court to make an order.
Then we shall have no other options but to move court to seek its guidance on the protection of our witnesses until the end of the case.
All interested parties will be looking ahead to the 18th of next month to see if Kyagulanyi can successfully challenge Museveni's victory, something the three previous petitions have failed to do. Edward Mhumza, NTV.